Today I want to focus your attention on gender-based discrimination against women in labor relations in Georgia. In the frames of the project European Union Women Against Labor Discrimination and Combating Gender-Based Violence, our organization has conducted the research and now I want to introduce you the key findings of the research. Nowadays, protection of human rights, labor rights of women faces numerous challenges in Georgia. Gender-based discrimination is observed in pre-contractual labor relations on the stage of vacancy announcement and interview, as well as contractual labor relations on the stage of payment and bonuses for men and women for work of equal value, promotions, and sexual harassment. It's noteworthy that significant changes have been made by the government of Georgia in recent years to ensure the protection of women labor rights, which is reflected to create the legislative guarantees for protection of women labor rights. The Georgian parliament adopted the law on gender equality, and amendments were made to the organic law of Georgia, Labor Code of Georgia. I also approved the law on elimination of all forms of discrimination and signed the Convention on Preventing and Combating Violence Against Women and Domestic Violence. The Convention on the Elimination of all forms of discrimination against women are entered force in Georgia, and also Georgia has ratified ANGLO's conventions, equal remuneration and discrimination in respect of employment and occupation. I want to first issue I would like to approach here is related to the gaps in Georgia legislation which conditions gender-based discrimination against women in labor relations. There is no legal definition of sexual harassment in Georgian legislation, which is why there is no administrative or criminal responsibility in impositions in case of sexual harassment. Furthermore, there is no regulation of equal remuneration for men and women, and the most important problem among other factors causing discrimination during pre-contractual relations in the non-existence of obligation to provide rejection explanation to a job seeker by an employer.
Don't be ratified?
Ratified?
Yes, not been ratified. Was this two acts?
No.
Два?
No.
Ну, наше принято. Наше правительство было принято. Вот
Yes,
эти,
it's
да.
the serious problem that Georgia has not been ratified international labor organizations documents, conventions, labor standards on maternity protection and workers with family responsibilities.
Наше принято.
Women discrimination often arises during the pre-contractual labor relations. According to legislative changes in 2012, the organic law Georgian labor code has prohibited discrimination during the pre-contractual relations. However, as I have mentioned, it's no legal obligation to employers to explain the reasons for rejection. Non-existence of regulated, allowed, or prohibited questions during the interview with the candidate may also be a factor in discrimination during pre-contractual relations. The employers put their best effort to obtain as much information as possible from job seekers during interviews. On the one side, there is their own interest to choose the most acceptable candidate, and on the other side, there is the interest of protection of candidates' private life and other rights. The vulnerable women group representatives discrimination cases are a significant problem on the stage of contractual relations during announcing of vacancy. In these cases, this is particularly zero opportunity to get employed. This is demonstrated when indicating any kind of restrictions or exclusions in announced jobs qualification requirements. This type of problem is especially in cases of women with disability when physical appearance are emphasized as a requirement. This second issue is related to the importance of retraining in order to defend women's labor rights. So while women are the only ones who use the maternity leave in Georgia, when returning to the workplace, the matter of their qualification becomes problematic. While women use maternity leave for 6 months, after returning, there is no support for increasing their professional qualification. They lost their equal chance to be competitive with employed men. For this point, it is crucial to ratify the conventions, as I mentioned above, 183 and 156 of the International Labour Organization. The mentioned issue is directly related to women's promotion. There are no transparent procedures in career advancement, therefore it's impossible to evaluate their gender sensitivity. In other words, we are not able to assess how gender sensitive, gender equal these procedures. This problem mostly occurs in public sector, except of ministries such as Ministry of Education in size of Georgia and External Affairs. The choice is made mostly in favor of men on the leading positions. The significant problem is the reimbursement provision during the maternity leave in private sector. In private sector, female employer get only 1,000 jail compensation, while in private sector, according to the law, the difference between 1,000 jail and the salary amount shall be compensated. In Georgia, as a rule, high-paid positions are occupied mostly by men. Even in these sectors, where the majority of employers are women, for example, in education and medical system, women's salaries are much more less than men's. The more important problem is the so-called glass roof, when the directors in majority are men than women. In spite of certain restrictions, short-term agreements stay as the good opportunity of discrimination. Moreover, in frames of short-term agreements, employers don't have any responsibility to explain why the labor agreement was not prohibited. In accordance with the research, main difficulties occur in employment of women with disabilities, which automatically cause discrimination and restriction in labor rights. Infrastructure accessibility is the main difficulties factor for employment of women with disability. This building may be adapted by the employer, but there is no transport for this women. According to the National Statistics Office of Georgia, in 2000 and 2013, there are 30,000 children who do not have the identity of the fathers indicated in their birth certificates. Mothers have to bring up children alone, but there is no record of a single parent status legal definition in Georgia. So this automatically leads not to receive social assistance and impossibility of assigning the benefits in labor relations. Georgian NGO Anti-Violence Network of Georgia introduced the draft law to the Georgian Parliament about the single parent status in 2014. The next issue I would like to introduce you is about transgender persons. In the results of research, allocation of transgender persons issues was conditioned by the difficulties and specifics which cause their discrimination in labor relations. The problems transgender people face in workplaces have no direct relation with labor legislation, but with issues of legal recognition of gender, which is not regulated by Georgian law. Georgian law on civil act states that amendments in civil act can be made to sex change if the person wishes to change the name and surname because of sex change. However, it says nothing about so-called interim period. Hence, the person is allowed to change the sex indication in his or her passport only after the full surgical interventions are executed. The This does not consider that it is not a one-day process, and there are the cases when being transgender does not mean that a person wishing to surgically change his her body sex prefers to stay in the biological body that he has, but the social environment is very important. The discrimination towards the women from ethnic and religious minorities is determined by some main factors in the reality of Georgia. Among these, the most problematic are access to education. Since 2005, tolerance and civil nation concept and action plan we have in Georgia. The goals of this concept are to provide equal opportunities to every citizen of Georgia to avail civil, political, economic, and social rights, regardless of ethnic, cultural, linguistic, or religious belonging, and to provide equal access of minorities to levels of education, and the right to receive education and communicate in their native language. Although, according to the estimation of the Tolerance Center of Public Defender of Georgia, which makes the monitoring of this concept and action plan, states that in the country regions where ethnic minorities are minority, for example, countries, the lack of kindergartens, school inventors, educational programs, books, and bilingual books is a huge problem. According to the bilingual concept, part of the materials, 30% are in Georgian language and 60% in minority language. Although the problem is that the teachers and children understand Georgian books in most cases. The problem is that nowadays there is nobody in Georgia which is assigned to explore labor security and labor rights violation cases. The result of the research shows that the members of the state sectors, as well as the representatives of NGOs and international organizations, consider the existence of labor inspector institute crucial.